And it looks like we're,
Ready to go?
yeah, we're ready to go. Let me hit this. And we're recording there as well. And everybody do this. 1, go ahead. 2, 3. Perfect. I got 3 little blips there that I can line up when we're done.
Cool.
So, okay, I guess I should really get started. My name is Tim Danbrook. This is Georgina Speaks. And once again, I'm lucky enough to have with us some people with some experience in these matters, because clearly I don't. John Mclean, lifelong resident and past councillor and regional councillor for the town of Georgina, past director of leisure services for till his retirement a few years ago. And Martin Nash, 65-year resident of the town of Georgina. So
Thanks. That sounds like too much.
yeah, I just want to make sure. Is that adjusted okay there, Martin?
Yeah, I'm good. Yeah.
Okay, good. So, and Martin has been a licensed realtor and broker actually for in excess of 40 years, has dealt with the lakefront properties that we're going to be talking about today for all of those 45 years, and is well versed in the matter. So I guess I guess what I wanted to address today is where we were and how we got to where we are now with this entire shoreline jurisdiction action correspondence, whatever the hell I want to call it.
You got 5 hours?
No, we're gonna do the abridged version if we can.
Good.
And the thing is that my thrust in all of it is that it's been not an improper process, intentionally or otherwise, but it's culminated in the bylaw came out in 2015. That was the catalyst of all of it. Time for a new bylaw. It was the normal process. 2015, 6 years ago now. And then a number of residents, about 300 residents, actually showed up at the town the night they were supposed to pass that bylaw. And in the past, when that's happened, in the 90s and in the 70s, you were there, council took that as their signal to sit down with the residents, sort something out with the residents, everybody get some lawyers involved so that there's proper representation. Mm-hmm. And that's what happened up until that point. When it happened this time, they moved into something called an ad hoc committee, and they decided people, instead of exercising their legal right to be heard through due process, they accepted the town's promises to use the ad hoc process to effectively have the same effect, people having the right to be heard. They turned their rights over to that committee and expected representation. And they expected to be heard by council, and that's a real serious point in all of that, because they trusted council, I guess is what you would say. So, any thoughts, John?
Well, in accordance with the town put out a document, a play-by-play document on how they were supposed to be dealing with the issue of the lakefront lands, and I don't know, there were 12 steps in it, and I think the third or fourth one was that they were supposed to set up an effective public consultation process.
Yes.
Which I assume they're saying that the ad hoc committee was the effective public consultation process. But that isn't the normal, in that normally, I believe, it used to be anyway, that it would be direct with council, not necessarily with an ad hoc committee that you can push off and not face the issues and take their recommendation, if there are any, from
Yeah, I have my understanding of it, and I've been immersed in it for like the last year, trying to figure out what exactly happened here. And my best take on it was that the residents, 400 residents, appointed 3 or 4 people to sit on that committee, and then when Ann Grant was highly active, and she structured everything, and then they appointed the town lawyer to sit there and guide everybody. So basically what transpired there is, anytime anybody raised a concern in the past, they would have a lawyer that would outline their concerns to council, or do a report, whatever, so proper representation of that side of the issue. But at this meeting, the residents had no representation, and Andrew Biggert was there for the town, and he has since stated right in a statement of defense, actually, that he was there to the benefit of his client, period. And he served his client well. So then basically, anything that came up to do with the legal, what the obligations of the town to that committee were, what the committee had a right to ask or not ask, anything to do with the process of the committee, process of information, then Andrew Biggert would pipe in and say, well, no, this is legally how, so he just ran everything. And they were told the council wasn't obligated, the town wasn't obligated to report back to them.
Here's mine.
Oh, okay, good, well, go ahead, Martin, we have time. So, anyway, my point is, and then when Anne Grant categorically was on more, she had, her style of management, and it is a style of management for bureaucrats, was, she was the boss of the town, the CAO of the town of Georgina, and if she decided what was in the public interest and for the greater good, all bets were off. Like whatever it took to achieve that she was right. She thought she was rightfully doing that, and she had no need for individual input because of the greater good, because of the public. And that's how she pursued everything. That's how she structured the committee. That's how the committee was instructed. Anytime they raised an issue, they were just explained away. No issues that they raised were actually addressed. And so basically that whole segment failed. And then from there, she left. Mr. Biggert stayed and continued to run whatever. And it ended up with what was supposed to be a proper consultation process as an alternative to the way we did it before was totally, they manhandled the committee and got them dispensed with. They completed it, they got the recommendation of the committee, they threw them in the garbage and moved on with what they had always planned to do, which was stop development on the lake. I guess that's my take on it. Anyway, sorry, John, I'm rambling now.
Well, no, I don't know. I don't think they necessarily wanted to stop development on the lake. They wanted to protect their interests and the interests of the town. We all have an interest in the view of
100%.
Lake Simcoe, and that was, I think, part of it. But they didn't even go to the next step, which they should have, which is to make a decision on whether they want to make a profit on the lands that they think they own, which we know some of them they don't own. It's Crown land, a lot of it, and they haven't made that decision. And that was the next step that they should be doing, and they could offer it for sale, lease, or both. And yet, they're also supposed to be able to determine who owns and who doesn't own. And they've never done that.
No, well,
and
that's...
the only way they could do it is through a proper process.
Well, that's my point, at least to hit now. If you look at that 12-point plan, like their whole jurisdiction action plan, okay, what do we do with this land? Do we want to sell it? Do we want to lease it? Do we want to... And then we have to go to the public to see if they want us to sell this property. They don't even know if they own anything. Like, when do you spend 6 years drafting complete sets of policies to govern what you think you might own?
Right.
So, Martin, I mean, do you have any clients?
Well, I've kind of been boots on the ground on this one. I've had quite a number of the, since you got me involved in this thing.
Yeah, thanks.
I had quite a number of,
and you're welcome.
Of people that they just don't know what to do. They say, what should we be doing? And I'm going, well, there's some processes you can do. They may be a little expensive. And I said, I think Tim's trying out a couple things that might help these owners, but so the town has scared them. They know they can't get permits, and they're right. They're in limbo. They don't know what to do.
Yeah.
And they're asking me, what do you think I should do? And so it's terrible to leave the public in that situation, because you should be able to go to the town, which we can't. They're not even open. You should be able to go to the town and say, what's going on with my property? And I don't know that they have an answer for that, and yet they put up the little bit of the fear stuff on them and say, well, you can't get a permit to shore up your boathouse or whatever, your fence or who knows what, because we have ownership problems, and so of some kind. And so what I have is lots of confusion from the actual owners. They want to do something, but they don't even know what it is.
But Martin, you have clients who can show title to some lands,
Yeah.
that can actually show title to the lands that the town are claiming.
Well, if they're claiming all of it, then of course, yeah, like I don't even know how they can even claim that, because if you have a, your deed and whatever, I'm like, go away, don't bug me, like I don't understand that they, that they have rights to come on and say, oh, whoops, we, you really don't. I mean, you can't do that to property rights, can you?
Well, the complexities of it are actually really simple. In part of this discussion I was discussing the other day, and what I had said was the town could actually issue permits now because either they believe they own it.
Yes.
The people are applying who believe they own it. There's the dispute. So if the town grants a permit, they have the owner's permission because they think they're the owner. So there's no impediment to them issuing permits. That's how they've done it in the past, because there's only two people. So then as always, they raise a new flag. When you make sense like that, they said, well, the Crown owns some of that. Perfect. The town can take the position. We will support anybody who's purchasing Crown land, because we've already said we want to sell it to you if we think we own it. If we don't own it, we would be happy to have you buy it from the Crown, because how can they say they don't want that? So then the town could, what they could do right now, they could have done it 6 years ago. They could have said, this is our policy. We believe we own a number of these pieces of property. If we don't own it and the Crown owns it, we will support you purchasing it.
It should be
Find out what you
up
own.
to the town to prove they own it.
Well, I
or
agree.
back off.
Or back off. Just start well, here, okay, so I don't know if you read the piece I put out the other day.
Yes.
Joe Dales, yourself, John Rogers, Rusty Russell, Linton Lecken Monteith, Patrick Fahey, Martin Nash. There's such a large host of credible, extremely experienced people, with a lot of wisdom in these matters because they have a lot of experience. Those are the people that drafted the existing policies today in '92. And nothing's changed, except council decided to find a way that they can turn down permits to see if they can bully everybody into doing whatever they want without ever having proven they owned anything, because you can't. Rusty Russell said you can't. Loopster Nixon said you can't. Patrick Fahey said you can't. Linton Lecken Monteith said you can't.
Can't prove title.
No, there is no ownership for anybody. It's not in any conventional sense of the word. So any agreement for the cohabitation on these parcels, the road and these parcels, has to come with a consensus of everybody involved. And everybody's always known that. And if you wanted to take a jaded look at it, they knew it now too. And they knew if they just said prove you own it, because they already know you can't, then that's their catalyst.
But you can prove it if you do a proper R plan.
Well, you can prove it. You can prove it if the town acknowledges what their road is.
Right.
Rusty Russell said, even Rusty said, nobody would win in a lawsuit. There's two things, his two statements at the end of the '92 meeting that he attended was, nobody would win in a lawsuit, and if I took this to the Attorney General, he would impose a 66-foot road allowance. If that 66-foot road allowance doesn't meet the water, town doesn't own the water's edge. And it's all fairly simple. If they were looking for solutions, they would have found them. But they are deliberately not finding a solution so that they can achieve some goal that they have of controlling development or eliminating new permits, eliminating development, eliminating old building. They want the waterfront cleaned off, and it's brutal. That's how you could look at it if you were a jaded property owner, I guess.
You don't have to be jaded to look at it that way.
Well, yeah.
If your property's falling down because the town won't issue a permit,
Yeah.
then it eventually can become a derelict property, and they can force you to tear it down.
Well, and it's becoming derelict by their actions.
Right.
Yeah, and they're doing that deliberately. That's my opinion. And it got a little more fun the other day because the town lawyer, his name is John Hart, and he's actually, I've had a number of conversations with him. He's representing his client, so I always have to remember that's his number one, whatever their wishes are.
Mm-hmm.
I can't take that. Like, he's doing what his client's asking him to do. And so, but he actually put forth to the court that people's languishing without permits and they're, they're at risk and their properties are at risk because of Mr. Danbrook's judicial review. And so I had to point out to the court, well, actually, this started in 2015, and then they started denying permits in favor of when the ad hoc committee gets done, so they're looking for resolutions, and then Mr. Biggert made his famous "we own everything" speech, and they started actually declaring we own it as a rationale for turning down permits. Then when the 8 of us challenged them legally and filed those suits, they converted that opinion to, well, then prove you own it. So first the committee, then the we own everything, and then that didn't work. The ever-evolving legal opinion, so then it's the goal, it's not the legal opinion, it doesn't mean anything. Their goal is to stop development, and that's why they're not making any. They could easily today say, our road is 1.5 meters past the travel portion of the road. That's what Andrew Biggert himself described it as, and we want to sell beyond that back to the people. They could do that today, or they could allow that to happen today. Take your time, John.
No, killed it. I hope. I didn't.
Call from unknown name.
Unknown name?
Well, who wants
Okay.
to talk to an unknown name?
Call from unknown name.
I can press
some
any
of them-
off and it won't.
It's the Internal Revenue calling saying that the police are gonna be at your door in 5 minutes. You get any of those lately?
Hello? Yes?
Well, anyway, Tim,
I remember you, Brent,
we can
certainly.
continue on there. You
We're
had,
just taping a podcast here for
Georgina Speaks.
Georgina Speaks. So I'm in the middle of that. Do you want me to call you back? Yeah. Great, no problem, right? I'll call you back. Okay, right, bye. Brent Eustace, Eustace Pharmacy.
Oh, yeah,
Played bridge occasionally in the past, so
nice.
anyway.
well, yeah, I was just going with Tim with what you were going to
Yeah.
do with that you'd made some recommendations, to the court or to the town, and they kind of shot you down on that. Is that because it wasn't their idea, or?
Well, I have a few. Yeah, I think we'll defer to John on that one.
You just had a hearing in front of
Superior Court judge, actually.
right, a judge,
Yeah.
and the judge basically, although he didn't say you must, he said, get your heads together and try and work this out, because that is the position you took, and the judge basically agreed. Now you got this next dissertation from the town saying, we're not going to do that.
Yeah, well, your characterization of it is actually pretty good. What I had said to the judge was, in recent weeks, John Hart and myself had some opportunity to discuss the issues. They literally go toe to toe on both sides of the issues, and it was really helpful because even though you're not going to come to an agreement, it's very helpful to understand. Okay, why is the town thinking? Why are they doing what they're doing? What's their take on it? Because I might have a totally misunderstanding of why they're doing what they're doing. So that information is helpful towards working towards some kind of a resolution. And so what I had mentioned to the judge, do you have any recommendations? I was hoping for some kind of a recommendation for mediation or something, some other mechanism that we could use to just sit down, let's get this done. So, but what she did say was, all parties are always advised that to attempt resolution of some kind without anything you can do to get resolved before you go to trial.
But they don't even know they haven't identified what they want resolved, because in the whole policy that they set out, they were supposed to determine the extent of the lands in question. They haven't done that.
No.
Number one.
They don't want to.
They were also in step 7 to award a contract to a surveyor to survey and create the R plan. That would totally dictate exactly what they want. They want to know, and certainly the public wants to know, who owns what.
Well,
Well, that puts a big elephant in the room, but it should be there.
Yeah.
well, there's no full proper survey of the road that's going to get done until they have an agreement. But they have to agree. Nobody's going to find out what you own. There is no ownership in the conventional sense. But if they put everybody in a position to solve their own ownership issues, like in other words, if they kept their word, oh no, we just want to help you quiet title. We just want to relieve ourselves of liability. we just want to identify our road. Well, they identified the road, 1.5 meters, Biggert said it himself, this is all we want. So, they're basically, this is one of my old catchphrases, is that they want to expropriate land off of people that they've already identified that they don't need for the sole purpose of selling it back to the people that they're expropriating it off of.
And who are paying taxes
And
for
many are
waterfront
paying
lots.
taxes, well, all are paying taxes based on their waterfront. That, so, yeah, anyway,
So you can't have it
so none
both.
of that, yeah, you can't, well, they seem to think that they can, and how they do it is they just stonewall everybody.
Yeah.
Yeah, so anyway, but I'm trying to contain this in such a way, what we could have done right from the very day one, and can still do today, they can identify the road. If they said, okay, our road is 1.5 meters past the travel portion on the lakeside to the already defined other side of the road. It's defined already that's from Old Homestead right to Dalton.
Right.
So if they could pass a resolution tomorrow saying, okay, would be our road. And then anything beyond, we will support the residents, the affected property owners seeking their title, either through possessory title claim of more than 60 years on Crown land, through the original land grants, the original patents, if they lend itself to it. Some deeds are available that way. Some, if it's not available, some the Crown owns, and people don't have a clear proof of the 60 years that they require, the town can say, well, we have no objection to them buying from the Crown, and the Crown would sell it. They just want the town to say, is that okay?
Right.
And the town has recently said yes to more than one.
Does possessory, Martin, you may be able to answer this, possessory title for 60 years, is that with a single owner?
No,
Or is it
no.
with consecutive
That is such
owners?
consecutive control tied to that property.
Anybody should be able to prove that,
Well, yeah,
based on title searches.
Yeah, it's a long process, it can get done, and there's a title search, I just finished paying, now I saw personally on behalf of a client, $6,000 for a complete title search. I got 12 binders of, a lot more than you need actually. This person just happened to be a historian, and so we ended up with quite a thing, but in the end, she made it very concise for me. The 60 years has been unfettered, and there was one person in that 60 years that had to be notified for some action that they had on that PIN number, and so there's a system for it. And then once you have that, you can go for a vesting order in the courts, or you can go to the registry office with your proof of possessory title. You have to have an R plan done, which then the town would be relieved of the issue of an R plan for the road, because as the people do it, part of their R plan is that road, defined as 1.5 meters past. So then it would just be surveyed eventually anyway, to go with the collection of surveys they have now. I mean, technically right now, I couldn't say, hey, John, let's go have a look at Lake Drive, because we don't know where it is. No, I'm serious, like, come take me out and point me to your road, show me where your road is. They can't. But they can restrict everybody's property, they can shut down the ad hoc committee, they can do anything and everything they want to do to avoid having any further permits issued, and then they can tell the courts, oh, Mr. Damrock's lawsuit, that's why these people are suffering. When my lawsuit's less than a year old, 8 months actually, and their nonsense here, whatever you call it, has been going on for 6 years.
Longer than that.
Well, yeah, longer, but since that bylaw, and then there's another thing. And if this isn't proof of like malintent, I don't know what is. They brought that bylaw in 2015, stated categorically as almost an emergency, something that's desperately needed. We need to clean up the entire bylaw. And now, because they couldn't get it through, they've put it off till 2023, 8 years. How much of an emergency was it that they were stating it was then, and then yet they can put it off for 8 years? To achieve an alternative.
Kicking that can down the road, isn't it?
Yeah, that's kicking a can quite a ways down the road.
The whole thing's crazy, and unfortunately, what we're talking about, because a lot of this stuff is legalese,
Yeah.
the average property owner, may not know what an R plan is, may not know possessory title, all of those
Yeah.
issues, which, again, all the town should be doing is following the process they put in place, and they are not following any of it at this point, or the bulk of it. They're not following it.
Well, they're saying that they were until my lawsuit, but the thing is, none of this started till the end of 2020. My efforts, the legal efforts, didn't start.
Right.
that meeting that took place was July of 2019. They've had the appraisal since fall of 2019 and refused to release them because they don't want anybody to know what they are.
The appraisals
For the land that we don't know if we own, based on their cockeyed, well, excuse me, I'm not getting into that nonsense, but,
well, it's just a word.
well, some criteria that they determine to establish the value of these properties that they don't know they own. In case you want to sell these properties that they don't know that they own to these people, we need a value. There's another thing. Now that we're broaching the subject, everybody on council that night was quite willing to consider the recommendation because it was a really good goodwill effort on behalf of the ad hoc committee to say, okay, you know what, in the interest of a resolution, we will agree, if the residents agree to pay the normal, what do they call it, excess land, what do they call it? The surplus land
Yeah.
fee for the town, whatever it is normally nowadays. If they agreed to pay that, and the town could sign a quick claim deed, not of ownership, of any interest that they may have in the property, there's a difference. I have a right, if I have a right to trespass over your property that's been there forever, I can sign a quick claim and I'm just signing it right away. It has nothing to do with ownership.
Right.
And so it was a really good solution. And Dave Neeson was quite ready to adopt it. Frank Zebo was, obviously Rob was, and Dave Harding was. Like, they were all looking at, okay, it's a possible solution. And the mayor didn't want it. And that night, if you look at what transpired, anytime anybody raised anything that made any sense, she'd hand bomb him over to the lawyer, and then he gave a 10-minute windy, and it went like this. Well, he did, and me and Aunt, God love Andrew Biggert, I actually said in defense of Andrew Biggert the other day, and I didn't think I'd ever utter that phrase, but he was just working for his client, whatever. But for the mayor to hand everything over to him that night, so that nobody actually had any discussion, council didn't get to have a discussion about it. And what he said was, oh, no, you need to do this because if you just use your own judgment based on the historical evolution of it all, people could challenge you that you were selling valuable properties and you're putting council and the town at risk. But if you do these appraisals, even if they come in at $1 million, then you can apply all that information, and if it ends up way back down here, then at least you've covered yourself. Now, what makes sense about that?
Well, nothing.
Right, but that's what he said, because the mayor needed this done. And the real thing that boggles my mind, 1 month before that, the head of your old department, Leisure Services, and actually announced in the Phase 3 study, they would get a report, spring of 2021, which would include these lands in these lands appraised in his report. And then a month later, they went to the people and said, oh, we need these appraisals for this process, but it wasn't. They needed them because they had already announced a month earlier that we would have it. Like the whole thing is really bizarre in terms of, there's some pretty straightforward things that you could do to just resolve this. And they don't want to do
Well,
it.
you come up with I read the report that you sent.
Yeah.
And I think that's a great solution, and it gets everybody sitting down, and it's gonna cover 95% of everything, and maybe the other 5 you gotta kick around a little bit, but, why not get to at least the 95%?
Well, yeah, and if you get to 95%, the other 5% of the odd circumstances that may
and there'll be
exist,
some of them, yeah.
and it would be where there's land that partly juts out and then juts back, so some of the land and then some of it's the town's waterfront because the road reaches, but here it doesn't really, there's some odd circumstances, but very few. And so, if you don't mind, I'd like to go down those points.
Yeah.
Go ahead.
Okay, so the resolutions that I recommended, and I only recommended them as a starting point for a conversation. And I want to make it really clear, if you live on the lake, this is not Tim Damberg dictating to council what should be done here. I talk on an ongoing basis with a large number of waterfront property owners. I believe I'm just speaking for what I believe to be the general good for all of those people. And so this set of recommendations, I thought, of resolutions would be a great starting point. And the conversation I was asking the town to have was with them, not with me. I agreed to step out of the process, not have a vote in anything that went on there, and I would turn my own will over to the group conscience of those lakefront property owners. And I think and the town might want to consider doing the same. So the resolutions were, number 1, a resolution defining Lake Drive in all areas that aren't already defined by either a plan of subdivision which shows a size or other planning actions from the past. So any area where it's not defined yet as from the south or east lot line, which is established, the road line, to 1.5 meters past the travel portion of the road. The Andrew Biggett described it that night when he was asked, what are they doing here? This is all we want and need for the town, and then beyond that, we want to sell it back to the people. They've already defined what they need. So that would be one resolution. The second resolution would have been to tell people they have 1 year to start their process to clarify their title, and 2 years to complete it. And they would do that through either possessory title, have their lawyer search and do, possibly it's available from the original Crown patents. There's deeds that say where the road runs through it, save and accept where the travel portion of it, like, all that stuff is clarified by this because the road's defined. So now we know what property we're talking about. And then, or if they want to purchase it from the Crown, the town could say, yeah, we would support that because we wanted to sell it to them when we thought we owned it. So now that we know that that's not possible, we have no trouble with them buying from the Crown. So that would be another resolution. And then the other resolution, so that resolution is a resolution that would give people clear instructions on how to get title to their property. And the other resolution would be in the interest of protecting the view of the lake, because that's in Ontario legislation and it's in all the past council discussions, that the view of the lake is the public interest that they have a right to protect.
Absolutely.
Yeah, so then notify another resolution. People have 1 year from the time that they get final ownership of their property to bring it into compliance with all of the bylaws and policies that deal with view of the lake. 50% obscurity, like there's a whole bunch of height of fence, height of hedges, all that stuff.
Right.
So 1 year, so that takes care of that, and it's a step in the right direction, and there'll always be, work that they have to do. And then also, at the end of the 2 years, when if anybody who has not pursued their title, the town retains the right to go to the Crown and acquire title themselves, because you got to tell the owners too. Like the owners, they've been sitting back all this time knowing that the town can't do anything about it, and they've been thinking that's pretty cool. But really, they have some responsibility that they've been shirking, not taking care of it themselves. So I mean, this puts everybody accountable. That's what I believe. Anyway, that's my 2 cents worth.
That was 4 cents worth. There's four possibilities.
Okay.
The most simple thing goes back to the original issue. Create the R plan.
Yeah.
Get off your butts. Vote for doing the R plan. That's a council decision, not a lawyer's decision. And I think it would be fair to ask the residents to contribute to the creation of that R plan, which, if there's an issue of purchase later on, if it even comes up, that anything they paid would be credited as part of the R plan creation, would be credited against purchase price.
Right.
So it just goes back to the simplest common denominator, which is find out where the damn road is.
Well, and then you're absolutely right. And that would be even the more simpler way, an easier way, just get that done and and make the decision, okay, ownership's not possible here, which they've always made that decision in the past. That's the conclusion that all the experts came to. And I always kind of look at it like you have all of this, and then you have Andrew Biggett over here. And you have all these people over here, and you have Andrew Biggett over here. So that clearly, there's some history to say that there's no resolution here, we have to agree. The town and the residents have to agree what's going to happen here. The town can impose its road categorically, so they should do that. That's what they can do, you're right. And then as soon as they do that, they can say, we can continue with the exclusive use, and they can indemnify the town, or the town could immediately sign release to any of those people of any interest, and then those people are responsible for that property. There is no liability issues here. This has been going on for 150 years and it's never happened. So.
Well, just how do you mind that?
Well,
Martin, you think that council or somebody wants to make a profit on these lands? Is that why they're doing it?
Well, if they feel they're mandated that way, I guess maybe some of them feel if you're if you're a farmer on the old homestead, you know, and say, hey, how come you guys give that stuff away for $2 a square foot or whatever, you know? So, I mean, there might be some sort of a mandate, but I'm sure that it has to be reasonable no matter what it is. And so then it won't be unreasonable for anybody. It won't be unreasonable for either side, you know, so.
Right.
Like, I don't know what is reasonable, but I'm sure that there's criteria for that.
But to be clear, you have to own something before there's any criteria applies. So unless they're prepared to go up the entire lake and do the searches and say we own what we own, which is never gonna happen, it's just not even it's not even feasible to do, so then there is no ownership issues here. There's whatever they agree on. And they know it, and that's what, so they say, I'll prove you own it. So then they get to stop everything for years and years and years.
True, that's what they've done.
Well, yeah, and that's what they're continuing to do. They don't want a resolution, that's the whole point.
Oh, I think they want a resolution, but I also think they want a pound of flesh from you.
Well, yeah. Well, there's that whole thing too, and but you know what? I've made it very clear that I will never pay a penny for costs for pursuing something I believe in, and something that was needed. Every resident that has contacted me in the last year, and there's been at least 100, has said, you know, what you're doing is worthwhile. So as long as I'm, doing something worthwhile, what I believe to be worthwhile, pursuing what I believe in, justice, then I'll never agree to pay a penny. I've agreed to walk away. And the only requirement was that council agrees to have a conversation with a group of property owners, not me, regarding the subject matter that we just discussed, those resolutions, things that we already know. We already know what they want for a road, 1.5 meters, fine. So we have that. Let's have that discussion. It's okay if we get that done. What's left? Okay, the properties. They've already said we want to give you exclusive use and continue it. They've said it. Great, so then they can do that. What about title? Well, we've already said we want to help you quiet title. That's their... See, they keep saying we want to do this stuff, but they don't want to do any of it. They want to just kick it as far down the road. They've already said 2023 before they even addressed the bylaw that they said was an emergency in 2015. So the town has to get more realistic about that these people have rights, and they're interfering with them seriously. And if this goes to judicial review, and it looks like it may, I'm in. Like, I'll go. I believe in what I'm doing, and I'm confident that nothing I am doing will be viewed as being frivolous. And I've had the arguments and discussions. Yeah, I mean, I'm confident. So I'm not worried about losing. I'm worried about winning for no reason. Like, no good's going to come of winning. How much of a remedy do the courts have the authority to do? And I believe where that will end up is they'll instruct the town to take no more steps until they prove they own something.
Yeah, which brings us back to what John was saying and what you and I have been saying since day one. I think our first podcast when we brought this subject up was why don't they survey the whole thing and then we can know what we're talking about. And that was like 2 years ago, at least for you and I.
They would have to instruct the surveyor.
Nobody listened to anything about that.
They have to instruct the surveyor to do one of two things: either establish 66 feet, spit it out. If that's what you're going to do it, or 1.5 meters past the travel, and instruct the surveyor. Anywhere the road's not already established by way of our plan or plan then that'll be the definition of the road. So do the R plan that way, and then they can allow. And the property owners, they're not fighting. I don't understand. Darrell Blanchard and Alan Darenfeld and like the gang that was. They sent out a survey the other day. Let us know if you want to have a lawsuit. Like 6 years later, like maybe I might want to have done that. They've had a $45,000 legal fund since day one. I never got a legal opinion. It's insane.
Well, as you said, the property owners have to be responsible for some of this as well.
Yeah,
it's not a one-way deal. So, but we gotta, I think, get everybody at the table. And as I say, I think John has hit the nail on the head. I think we did it many, many times. Is get an R plan and see what's out there because it's like. Arguing with the wife and you're right, but you're not.
Yeah, and there's no benefit to winning the argument.
There's no sense arguing.
Why do I care? Why do I care if I win this argument when there's no benefit to it?
Yeah, that's right.
Well, we're in the middle of one of those classics, actually. We're 6 years into one of those, so nobody's going to win this no matter what. Even Rusty Russell said that. So,
Well, it's hard to cut jelly into a solid piece, that's for sure.
Yeah.
And that's where we're at right
Yeah,
now.
but there is solutions.
You guys have said it from day one. If council wants a real solution,
It's there.
it's there
been
right in
there
front of
forever.
them, and to protect themselves,
Yeah.
so that it doesn't seem like they're acquiescing, then ask the residents to pay a portion of the survey. But I have no idea what the survey's gonna cost.
The residents
Well, I know
made
they
an
made an
offer for a $25,000 deposit out of their $45,000 legal fund. That was a really goodwill attempt to get the log jam busted and get moving forward. And the town won't even talk to anybody. And long before this lawsuit, like they won't engage. You've had your say. We're not talking to you anymore. Nobody can talk to anybody until this whole process is done.
Then this document is a pile of crap.
It is a pile of crap. It was designed to win Ann Grant, and when Ann Grant designed it, to never have to come to a conclusion because she was never capable of it. She always just would go on and on and on, and then you'd move down the path that she wanted you to move down because you had no choice, because there's no alternative. And this provided no alternative either. And I even offered to incorporate this into that process. Why don't we just say as part of step 4 or 5 or whatever, let's have these conversations with this as part of the shoreline action plan. Let's do an exploratory into these issues then, and with the residents, and do this. Like there's lots of opportunity to resolve things now, but they don't want that. They already have a goal in the end, and I believe it's to stop out, never have to issue another permit on the lake. No, I'm telling you.
Okay?
Because they could easily have shut it off.
Yeah, for a second.
Well, that's
Just might
nothing
be
good.
weird.
I'll edit it out. Oh, yeah. So,
See, this can all be edited, so it doesn't matter, guys.
I generally don't, so we'll see how that goes.
Cool.
Yeah, very good. It means
Well, you try not to edit, well, you don't edit anything we say, but,
no, well, you know what? All it means is that we're not as cool as we thought we were. So.
yeah.
So, to summarize, to conclude, or whatever, I want to make a couple of things really clear. Those resolutions that we've discussed here, that were part of what I proposed the other day, were just a recommended starting point for a discussion that I was hoping that council would agree to have with, and start with staff, and the lawyers could attend as well, however that works, but as a starting point for a conversation to the final resolution of the lake. And I think all the elements are there, and I agreed to step out of that conversation and allow a group of the residents, which I'm working with, to carry on those discussions and hopefully come with resolutions. We're very close. And the feedback I get and got is, why the hell should, Tim Damrick be telling council how, Tim Damrick is not. These proposals are being put forward in an effort to resolve the impasse between council and the residents. I got nothing to do with that. I'm trying to get out of this with my skin. How's that? So.
And I don't have a dog in the fight, so.
There you go. So,
Onward, council, do what's right.
Yeah, there we go.
What you're supposed to do.
Yeah, so, I'm Tim Damrick, this is Georgina Speaks, and we're just gonna conclude. So Martin, if you can just lean forward and say goodbye, everybody.
Take care, folks.
And if you could tell council to straighten up and fly, right?
Well, I don't know if I can do that.
All right.
That's a big issue.
You always have too much respect for issues, eh? Okay, so if you can just say goodbye,
Goodbye, folks.
and hit your little red button,
Got it.
and if you can do the same, John?
And everybody that's watching or is interested, follow up and read up on what Tim has written. He's done his best to represent everybody. So goodbye for now.
Thanks, John. Tim Damrick, Georgina Speaks, and we're just signing off, and we'll be producing more and more. We'll be publishing more stuff around this issue. It's going to get fairly intense over the next month or two because we're trying to get resolved. So take care. Have a great day, everybody. See you later.